of the co-sponsors or proponents of this particular bill. He is Roxy Nelson, the member of Parliament for South Dayi. Hello, Honorable. Welcome to Eyewitness News. Are you surprised that a private citizen, a lawyer for that matter, and a journalist has gone to the Supreme Court to ask for the reliefs he's seeking from the Supreme Court?
Good evening to you. I'm privileged to have joined you. As to surprise, I'm not, because Richard Sky is doing the bidding of his sponsors, so that is fine. I'm also a sponsor of the bill.
No, but let me interrogate that. No. Please, because he's gone away. He's gone to court as a private citizen or as a citizen of Ghana. You know, that at least that is what we know.
I don't know. I beg you.
No, you wait. Let's just clarify this. He's gone to court as a citizen of the country. So I'm not sure what you mean by he's doing the bidding of his sponsors.
I have listened to him speak. He granted interview. He went to court, but he's still in the media granting interview.
No, this interview was a couple of days ago on the Citi Breakfast Show. You heard Bernard Able's voice in there, you heard Caleb Kuda's voice in the zoo. This was a couple of days ago.
So you see, so you should have told me that you are playing a recorded interview. So it would have guided my response.
I apologize, but it's an interview that was granted, I think, sometime last week.
So now I'm aware that he has gone to the Supreme Court. And I've seen Richard around the court premise, the parliamentary premises a couple of times while we were considering this bill. But whatever it is, we all operate within the fringes of the law and within the remits of the law. So if Richard says that Article 17 clause, which one did he provide? Do you have it immediately?
He provided 17, Article 17, which deals with the restrictions, imposed. Let me quickly refer to that if you don't have yours.
Yes, I think he quoted 17 something. I'm in a vehicle, so I'm not able to.
Okay, so you can proceed with your points whilst I make that available to you.
So let me proceed with my point. I'm saying that Richard Sky makes the point that a person who is a lesbian is being prescribed from adopting, and Richard says that is wrong. Based on which law are we wrong? Because when you are a criminal in this country, you cannot adopt. Is he aware? Is Richard Sky aware that when you are a criminal in this country, when you are a convicted criminal in this country, you cannot adopt a child? Is he aware? So we are prescribing a conduct. It is within that premise that we say that a lesbian, a gay, and all those who belong to those categories of LGBTQ plus cannot adopt a child. You don't want to give birth to a child and you want to adopt somebody's child and impart what to the child. Adoption is based on the welfare principle. So what sort of welfare are you seeking for the child if you are gay? So Richard shouldn't make arguments in isolation. He should make arguments in the fact that the adoption principle of a child within the Matrimonial Causes Act and all that, and Adoption Act, is about the welfare of a child. When a child is a child, the person who is adopting the child stands in what we call in loco parentis, in place of the parent of the child. So would a child who has been brought forth by a male and a female bring the child forth in the ways of gayism and lesbianism? They won't do that. So if you are not willing to give birth to children, why do you want to adopt one? That is why we brought this provision in the law.
But is it a novelty that someone who doesn't want to give birth to a child wants to adopt? We have a number of couples around, or even individuals, who are not interested in giving birth or going through the process of giving birth, but they're able to adopt, and a number of them exist. So the fact that somebody is gay or somebody is gay and so is unable to give birth on his own or her own should not prescribe that person from adopting.
Yes, I'm happy you, the person interviewing me, you are also a lawyer. So we speak of values. When you adopt a child, we expect that the child will be imparted with certain values. We are saying that the gay and the lesbian values cannot be imparted to our children at that age. Allow our children to attain majority, 18. They can make their own decision. And at 18, you cannot adopt, but the person can be your friend. At that stage, myself and my co-sponsor, we are not bothered. But until such time, we will not allow anybody who want to act in local parentage to impact certain values to the child. So unless we are saying that the values we espouse in our bill is not the values espoused by the Ghanaian people. So let me ask you, my brother, and I said this elsewhere. Do you know how tobacco, cigarette is manufactured, is produced?
You tell us.
No, I'm asking you.
So educate us. Yes, I don't know.
Okay, so cigarette is produced from a vegetative matter called tobacco. It can be planted in any flower pot in the premises of Citi FM and Citi TV at Tesano. Once it's watered, it will grow into a tobacco. It's from a vegetative plant. There's another vegetative plant that can grow in another flower pot planted in the premises of Citi FM or Citi TV in either Tesano or Nadabraka if it's properly watered, and that's marijuana. But the nation has seen it fit to ban the smoking of marijuana and allow the smoking of vegetative tobacco, even though both of them grew from the wild. Do you know why?
Why?
Because of the effect it has on the public health. That is why two plants growing in the wild, both of a certain nicotine and THC quality, cannot be smoked by the public willingly. One is banned, one is not banned. Two plants grown in the wild. I have a right to smoke both, don't I? But the state has banned me from smoking tobacco freely, even though the Director General will tell me that if I smoke tobacco, it is detrimental to my health. But that is the health people. The state is not concerned by that matter. He has allowed me to smoke tobacco cigarettes. But the same state says that I cannot smoke marijuana because of a certain value that it has and a certain effect that it has on my health as a person, and by and large the public health. So rights are not absolute, my brother. I have a right to life, but I don't have a right to take my own life. If I do so, I will come in conflict with the law and I will be punished. So rights may be prescribed in the Constitution for all of us, but they are not absolute. They are circumscribed. They are subjected to certain conditions. So anybody who says that people should have the right to do as they please, as part of this LGBT thing, I'm shocked that you journalists are not talking about the fact that it's not about two men or two women desiring to have sex with themselves, but others desire to marry a pig, a dog, a goat, a cattle, a sheep, and a donkey, and bring them in the house as their spouses. I am shocked you guys are not talking about it.
No, I think it has to do with consent. So what two consenting adults, choose to do with their lives. I mean, I think that's what the discussion is. In the case of animals, I'm not sure if they have the capacity to even consent. They are not able to do so. So that is for now out of the question.
We are talking about a certain conduct of LGBTQ plus people, which has attained a term of art. And you are saying that we should allow two men to sleep with themselves, two women to sleep with themselves, but we shouldn't allow a man who says, I want to sleep with an animal?
So, yes, I mean, so the discussion really is, yes, we may agree at a certain level that this conduct should not be allowed to fester or to grow in society.
No, you are saying that a man should sleep with
I'm building a point. I mean, I think we've moved on from there now. I'm moving to the next leg of the discussion.
No, let me respond to you. You made a point that we should allow a man to say that he wants to sleep with a fellow man, but we shouldn't allow another man who says that he wants to sleep with an animal.
No, but I made a point about consent. Right? How about consent and capacity?
Who is talking about consent and capacity? Is it not the case that two people can agree that they want to go and take another person's property? There's a consent there, but there's a crime that has been committed.
No, the consent is not with the owner of the property to be taken. If the consent was with the owner of the property, then that would not be a crime.
Exactly. That is the ingredients we are creating. So now you are talking about ingredients of what constitutes what we call stealing. So what about two persons who agree that they want to smoke marijuana? Have they not agreed?
But I think you are talking about. I'm not sure if you are mixing conspiracy and consent. If the two of us agree to do something, that'll be conspiracy, will it not? If I agree with you to do something with you, which has something to do with you, we talk about consent, or?
Yes, you just said consent. So you are talking about consensual sex.
Yes.
Yes, consensual sex. What is consensual sex? Between two men. The act is prescribed. And you are saying that because two people have agreed that they want to have sex with themselves, it should be lawful. No, the act is what is prescribed. So when two people agree that they want to go and steal another person's property, the fact that they agree that they want to go and steal is immaterial. The fact that they have committed the act is what is prescribed. So consent is not always material in the formation of a crime. The act in itself can constitute what we call a crime. So that is why two persons can agree that they want to do something, but what they want to engage in, if it's criminal, the agreement is no longer a consent, but it is a conspiracy. So when two men agreed to go and have sex with themselves or with other persons who are also males, it is no longer a consent, it is a conspiracy to engage in an offense.
I see. Now let's move the discussion on. Many people, I mean, generally agree with the bill, the fact that the conduct should be prescribed, etc. In fact, that appears to be the general view of many Ghanaians from surveys done, etc. But what many people do not seem to agree with is the custodial sentence. So, can something be done about the fact that persons caught in this act or persons caught by this law, I mean, if President assents to it, rather than being jailed, could be given some other form of punishment? Is there anything that can be done about that?
Why? We considered it. You think we did not? This bill witnessed the submission of over 200 memoranda. And don't make the mistake that these 200 memoranda didn't consider all the perspectives to this bill.
Yes, but now that it is out, it appears that is a major. Yes.
So let me ask you. A person commits an offense and is convicted by a court of law under any provision of this bill by, say, prosecution from, say, the Nima police station. So he gets to court, his prosecution begins, and then he pleads guilty, and then he's fined. All right? So he pays the fine and he walks. That is non-custodial. Even though the person has been convicted, is not sentenced to a custodial sentence. So the option for the court is to impose a fine. So he pays, let's say, 2,000 penalty units. So 2 times 12, that is 24. So he pays some 24,000 Ghana cedis and then he walks. Then a month later, the same person is brought before the court for a similar offense. Then the court is compelled by circumstances to impose another fine. Then 2 months later, he comes back for committing a similar offense. Mr. Adonu, are you saying that when this happens before a court of law, where an offender is brought before the court on charges of repeated offenses that have already been determined by the court in respect of the same person, it shouldn't be, there should be no custodial sentence imposed on the person. You see, the imposition of a custodial sentence is to say that the person is a danger to the greater society. It's not simply about putting the person in prison. The fundamental principle about putting somebody in prison is that the person poses a danger, is a pollution to the greater society. So he must be isolated and confined until such time that he becomes puritanical, as we say in criminal law, in terms of his offending mind. So if you say that gay people should not be persons who will be convicted under the provisions of this law should not be convicted and sentenced to custodial, but only a fine, there will be so many repeat offenders, this society will be overwhelmed. So the prison option is there for a reason. And that is why we have also created a provision, a penal provision, allowing the court to impose a fine or a prison term or both, depending on the circumstances and gravity of the offense that have been brought before the court.
I see. Just on a factual matter, I know that the bill was passed unanimously by Parliament and you adopted a voice vote method. Can you talk to me about the number of people in the chamber at the time? Will you know, as in terms of quorum?
The number of people in Parliament is determined by documentary evidence. It's not determined by the TV cameras. So if you wanted to speak to the number of MPs present in Parliament for purposes of his business on Wednesday, that's tomorrow will be a week, we have to have recourse to the evidence available.
Very well. That's why I asked whether you know. Maybe it has come to your notice, or maybe you checked as a matter of fact.
I've seen the release, and I don't know the tangent upon which they are proceeding.
No, of course, I'm mindful of the fact that the matter is in court, and so we should be careful about how we discuss it.
The Supreme Court is very clear in Abdullahi versus Abdullahi. That is Abdullahi versus Attorney General. Courage is not determined by video cameras. It's determined by the documentary evidence of number of MPs in Parliament. Today, for instance, we've proceeded to work on the Environmental Protection Act, the Environmental Protection Bill. We were just about 60 on the floor enacting the law, but there were a lot of MPs at the Appointments Committee which were vetting the president's own nominees. Is the president saying that we shouldn't vet his nominees once we are enacting another law that is being brought in his name? So there are protocols and procedures in Parliament to determine attendance. And this matter in the Supreme Court, my brother, when we get to that bridge, we'll cross it.
Very well. I mean, the discussion has also brought up the matter of community sentencing. Again, will you know, I know, of course, that your colleague, Francis Xavier Sosu, has presented a private member's bill or submitted a private member's bill to the House. Will you know the status of that as we speak?
The submission of a private member's bill by another MP has nothing to do with what we have done.
No, I'm just asking because I said it has also come up that instead of jailing them,
I see exactly the angle angle at which you are proceeding. But I'm saying a private member's bill in respect of community sentencing is no law. The law enforces that every offense that is determinable under an enactment of Parliament of the Republic of Ghana has a sentencing regime provided by the same Parliament of Ghana. And that is how we are proceeding.
I see. Interesting days ahead. But one other matter that has come up is, I mean, in the general public, is can somebody challenge a bill that has not been assented to yet? What's your legal opinion on that?
No, you and I are trained minds. You and I are lawyers. I may be your senior in the law, but the fact that we're all lawyers is very, very important. If you read the interpretation placed under an act of Parliament and then an enactment of Parliament, all right, in the Constitution itself. And then when you proceed under Article 106 of the Constitution, to the extent that a bill that has been passed by Parliament but has not been assented to has certain definite procedural stages to go through. So, for instance, where the bill is remitted to the office of the president and is not minded to exercise his assent but to want to veto, you know the timeline that the Constitution places on the president in doing so. For instance, it says that if he is minded to refer the bill to the Council of State, then he must refer to Parliament within 7 days. But where he will not refer the bill to the Council of State, but he is simply minded to exercise his veto, then within 14 days he must give reasons for doing that, and also indicate that perhaps he has reasons, he has reservations regarding certain provisions of the law. All those provisions in the Constitution never referred to the law as an act of Parliament but as a bill. So, if anybody proceeds to interpret the stage of this bill as it's passed through Parliament but awaiting assent as an act of Parliament, not gazetted, not numbered, has no effect in law as an act of Parliament, then of course you and I should change our mind and our position on the jurisprudence we were taught in legal methods and all.
I see.
So a bill, look, there are a lot of case law on this matter. A bill, until it receives a presidential assent, constitutes merely an intent of Parliament. It is not a law. It is merely an intent of Parliament to pass a legislation. In fact, are you aware that the Speaker and the Clerk can refuse to remit this bill to the office of the President for his assent? And that's the end of it.
Yes, speaking about 106, I mean 106.10 actually talks about what happens if the president refuses to give assent to the bill. It says that
recounted that.
Yes, I'm just making a point. So okay. It says that Parliament can pass a resolution of 2/3 of its members to make the president do it, and they said the president shall assent if this happens. Yes. Do you? Yes. Let me just land. Parliament passes unanimously. It does appear that some divide is emerging, led by Afenyo Markin. He initially tried it, but it was aborted somewhat. It appears that the government is now, executive is now on one side, and Parliament is also on another side. Given a kind of system we run, where the separation of powers is not watertight, are you concerned that the unanimity that this bill enjoyed in its passage may suffer a setback if it should come back requiring this 2/3 majority?
The bill may suffer a setback in the manner of original persons who supported it, original persons like the Honorable Afenyo Markin, who gave it 100% votes at the principal stage, which is the second reading, where they voted that yes, the bill is good enough to proceed to consideration. It may suffer their support at this stage, but I don't think their support will be sufficient enough for us to get 2/3 majority to support it in Parliament.
Very well.
Let me explain why. The vote on this matter, if we go through the procedure provided by the Constitution, where the president is mandated to indicate his reservations in respect of the provisions of the law, and also propose amendments and justify them, which will be forwarded or remitted to Parliament for consideration, and after which Parliament must by 2/3 majority resolution pass it into law, and after which the president will have no option than to assent to it. We are waiting for MPs who will cast their vote against this bill. All right?
Very well. Thanks so much for speaking to us. Pleasure as always. Roxanne Nelson,
it's my pleasure, my friend.
Yes, is member of